Welcome, everyone. As I bet almost everyone in this room knows, I'm Randy May, president of the Free State Foundation, and I'm pleased to have you here today. It looks like it's raining again, so this is a terrific turnout. I say raining again because there was a stretch. Some of you may remember when we did, I think, 4 or 5 events, and this goes back some years, but it rained every single time for one of those events, and some people thought I had to deal with the farmers, that I was collaborating with them to make it rain, but that's the way it happened. But I'm delighted with the turnout. So we're here today to celebrate the publication of the Free State Foundation's latest book, and that's a reader on net neutrality and internet freedom. Pretty sexy title, right? A reader on net neutrality and internet freedom. The book's edited by me and my colleague, Free State Foundation senior fellow Seth Cooper, whom you'll hear from a bit later. I'm really pleased that we have the prominent speakers that we have here today, and I'm going to introduce them as we go along. I will do want to announce that Babette Bolema, who was scheduled to speak, has a family emergency. It just came up, and she notified me just a few hours ago that she couldn't be here today. But Tom Johnson and Andrew Smith are right here with us to give us the benefit of their expertise and to educate us. Now, I want to just highlight our Twitter handle. Sometimes I forget this, and I don't want to do it today. It's hashtag net neutrality reader. So please feel free to tweet as we go along. Hashtag net neutrality reader. So this book, I'm just going to say a brief bit about it. It contains 24 different selected pieces from FSF's published work that explore the legal, policy, economic issues, the rationales that support the FCC's December 27, 2017 Restoring Internet Freedom Order. These pieces range in time from one of mine published in September 2013, that's the earliest, called It's the Consumer Stupid. I consulted with James Carville on that title, to Seth Cooper's February 2018 piece on the likelihood of success of FCC preemption of state net neutrality regulations that are inconsistent with the Restoring Internet Freedom Order's approach. So in addition to those pieces which we collected, the book contains a fairly lengthy introduction, and I should say quite substantive introduction, that puts all the material in the book into context and brings matters up to date as of this past summer when we had to go to publication. Now, by the way, just during the last couple of years, the Free State Foundation has published over 100 papers and blogs relating specifically to the net neutrality controversy. So putting the book together, we took care. We took a lot of time, really, to cull through all of these pieces and pick out selections that we thought would be most useful to scholars as well as others, and tried to put together a book that would be a good practical resource. So that's what it is. You know, I'll admit right up front, it's not going to be the book that you look to for the other side of the argument. And those of you that are here know that I always recognize, of course, there there is another side to the argument, and I respect other people's views, but this book is a book really that we think is a scholarly defense of the Restoring Internet Freedom order. Now, I want to acknowledge that in addition to Seth and I, and Ted Bolema, who is going to speak today, and Mike Horney, who is FSF Research Fellow, we're all FSF in-house people, and we all contributed to this book. But in addition to those of us with FSF, we had contributions from members of our Board of Academic Advisors, which we think is quite distinguished. And those contributions were by Daniel Lyons, Joshua Wright, Gus Hurwitz, James Prieger, Tim Brennan, Dennis Weissman, and Robert Crandall. And I'm sure a lot of you are familiar with many of those academics. They're all academics. As most of you know, the material in the book, I don't have to tell you, is still very timely. The RIF order, I'm just going to call it sometimes the RIF order, Restoring Internet Freedom order. It's on appeal in the DC Circuit. It's now being briefed. There's a lawsuit in California. It's been put on hold. I'm not going to say any more about the litigation because we have Tom Johnson here with us, so I'll be quiet on any of that. But I am going to, it's not often you read a book's dedication, right? I'm going to read this dedication and then see why. You know, the first 5 books we did, I felt under a compulsion, I think, to dedicate them to my wife, right? For Laurie. And then when we did more books, I did my children, you know, because Laurie said that's enough. So this book, the dedication reads, "For my grandchildren, Samantha, Kieran, Benjamin, Francis, and Zachary, with the hope that sometime before they have children of their own, the net neutrality controversy will be ancient history." Or, I'm not through, or at least history. So anyway, and then Seth has a nice dedication as well, of course, and you'll have to get the book for that. Now, well, speaking of getting the book, so the holidays I know are fast approaching, right? And a lot of you are thinking about what's the ideal gift. I know you're beginning to think about it now. An ideal gift, stocking stuffer, whatever. Okay, so now you're thinking about it. Now, this book, and you're also thinking about getting something that's reasonably priced. Now, this book is available on Amazon. It's available out there, if there are any left, for $8. We put some out there you can pick up, but on Amazon it's just $9.95 on Amazon. Or if you don't like a physical stocking stuffer, the ebook version is available on Kindle, on Apple iBooks, Barnes & Noble, Nook, and 3 or 4 other platforms for $2.99, okay? So think about that. Now, I think I mentioned the Twitter handle, #NetNeutralityReader. So with that, what I'm going to do, here's what the order of the program today. I'm going to introduce in a moment Tom Johnson, the FCC's General Counsel, and then we're going to hear from Seth Cooper and Ted Bolema about, they're going to speak for just a bit about their contributions to the book, what's in the book with more substantively than I did. And then after that, we're delighted to have Andrew Smith speak from the FTC. Now, I already said Tom Johnson's General Counsel at the FCC, and many of you that are here on a regular basis know that I shy away from reading these introductions because we print up this nice bio sheet, which you all have. So I'm not going to, with Tom's permission, I'm not going to read the whole thing. Maybe I'll just pick out a couple things. But Tom was appointed General Counsel in October 2017. Of course, that means he's the chief legal advisor of the commission, and he reviews the adequacy of the commission's rules from a legal perspective, defends the commission's actions in litigation. There's always plenty of that, I can tell you that, from observing over 4 decades. And he acts as a resource on internal issues. Previously, I'll just note that Tom was Deputy Solicitor General for the state of West Virginia. So I don't want to take any more time. You've got the rest of the bio, and with that, please welcome Tom Johnson, please.
Well, thank you, Randy, for the kind introduction. It's an honor to be here to address the Free State Foundation to talk about our Restoring Internet Freedom litigation. I admire the Foundation's dedication to free markets and the rule of law, and I thank the Foundation for its interest and participation in the Restoring Internet Freedom proceeding, or the RIF proceeding, as Randy called it. If you want more acronyms, I've got plenty for you as General Counsel of the FCC. So when it comes to this litigation, I'm reminded of that preeminent legal scholar and oral advocate, Yogi Berra, who said purportedly, this is deja vu all over again. This is now the 4th time, at least, depending on how you count, that the Commission will appear before the D.C. Circuit Court of Appeals on orders that attempt to grapple with how to use the Commission's limited authority under the Communications Act to regulate broadband internet access service. And I'd like to talk to you today about why I believe that this time the Commission has gotten the balance exactly right. In regards both to its decision to classify broadband as a Title I information service, as well as the light touch regulatory framework that the Commission has put in place. So let's start with classification. The debate over net neutrality, as it's popularly known, has generated intense public interest and passionate opinion. But the most important legal question in this case is, I'm sorry to say, a relatively dry matter of statutory construction. The stakes involved in how we resolve that question, though, have profound impacts on the internet economy. So the question is this: is broadband an information service under Title I of the Communications Act, or a telecommunications service under Title II of the Act? Now, for most of the 22 years since these terms of art were adopted by Congress in 1996, there was a bipartisan consensus at the Commission that broadband was a Title I information service. And that's the same classification that the Commission has now adopted in the Restoring Internet Freedom Order. That classification entails a light touch approach to broadband regulation. Now, this consensus has its origins in the text, structure, and congressional purposes expressed in the 1996 amendments to the Act itself. Those amendments declared that the internet should, quote, be unfettered by federal or state regulation, and it made clear that information services, those are those Title I services subject to the light touch approach, include, as set forth in Section 230F of the Act, quote, a service or system that provides access to the internet. That includes broadband. 2 years later, in 1998, the Commission submitted a report to Congress known as the Stevens Report that similarly concluded that internet access service was an information service. Applying the statutory definition of information service, the Commission reasoned, paraphrasing somewhat the language of the definition, that it was an offering of a capability for acquiring, retrieving, and utilizing information. In layman's terms, your internet service provider enables consumers to access and use content on the internet. Starting in 2002, the Commission adopted a series of orders concluding that broadband delivered over different physical media were all properly classified as information services, including first, cable modem service, and we'll get back to that in a minute, wireline facilities, wireless networks, and power lines. Until 2015, this bipartisan consensus persisted. While the Commission made some attempts during this era to apply new rules under Title I to regulate the conduct of broadband providers, those rules, with the important exception of a market-based disclosure requirement, which I'll return to shortly, were deemed by the Federal Court of Appeals in DC to exceed the Commission's authority under the Communications Act. So as a result, during this era, the Commission's efforts to intervene in the broadband market could best be described as case-specific and on the minimal side. But a funny thing happened during this extended period of light touch regulation. Broadband providers invested over $1.5 trillion in new networks to connect Americans to new products and services. The internet and social media revolutionized how we interact with the world in which we live. And the internet economy has created millions of new jobs. The internet, in other words, in 2015 appeared far from broken or in need of a regulatory correction course from the FCC. The story, of course, as you know, did not end there. In 2015, the Commission, under the prior administration, reclassified broadband as a Title II telecommunications service. Now, Title II operates a lot differently than Title I. It applies to covered services the same utility-style regulatory framework that applies to traditional telephone networks, dating back to the old Ma Bell system. By reclassifying broadband as a Title II service, the Commission assumed the authority to impose conduct rules, this is what's called net neutrality rules, to prohibit certain practices of internet service providers. These were broadly worded static prohibitions, including an internet conduct standard that included a vague restriction against providers unreasonably interfering or disadvantaging users' ability to access the content of their choice. In 2017, under Chairman Pai's leadership, the Commission took a fresh look at the regulatory classification of broadband. The Commission detailed the consensus that had existed over 2 prior decades and further noted the significant benefits of broadband investment and innovation that occurred during the light touch era. It concluded as a legal and policy matter that the long-standing Title I classification of broadband should be restored and the conduct rules repealed. In place of those rules, the Commission adopted a robust market-based transparency regime in which broadband providers will need to disclose their network management practices, performance, and commercial terms of service. This will provide consumers with critical information when choosing among providers. Furthermore, this regime will facilitate information sharing with the Federal Trade Commission. We'll hear more from them shortly. And the Commission noted that providers who engage in practices that are demonstrably anti-competitive or harm consumers can be held accountable on a targeted, case-by-case basis by the FTC and other consumer protection and antitrust authorities. Now, this Restoring Internet Freedom order, as you know, has now been challenged in court. 16 petitions have been filed challenging the legality of the new rule. The cases have been consolidated before the DC Circuit Court of Appeals and are currently being briefed. Oral argument is scheduled for February 1st of next year, and we can hopefully expect a decision later that year. So returning to this classification decision, how am I confident that the Commission's decision is consistent with law and likely to be upheld in court? Well, if oral argument in this case played by the rules of the old TV game show Name That Tune, I would say I could argue this case in 2 words: Brand X. Now, I'm not actually advocating this as an oral argument strategy. But Brand X is the name of the U.S. Supreme Court case that held back in 2005 that the Commission acted reasonably by classifying broadband as a Title I information service. In our brief, our principal response to the petitioner's challenges is simple. They are attempting to relitigate Brand X. Petitioners, of course, recognize they need to distinguish this case, but their efforts to do so are unpersuasive. Their principal response is that the state of broadband technology has evolved from the time of the 2005 decision. Petitioners argue that the types of internet service providers that the court had in mind when it made its decision were so-called walled garden providers like AOL or Netscape. As you may remember, these providers typically offered consumers not only access to the internet, but also a host of add-on applications like email, news feeds, or online chat groups. Petitioners argue that these additional services were critical to the court's determination in Brand X that cable modem service, which was the order on appeal at that time, was an information service. Today, the petitioners argue when consumers make much more use of third-party apps and websites or email, news, and other content, the broadband access service itself is more like a traditional telephone network, simply transmitting data. Now, there are factual problems with this narrative. The internet service market had already started evolving away from the AOL walled garden approach by the time of the Brand X decision, and broadband providers today still do provide email and other add-on applications. But the most compelling reason that this argument does not work is that Brand X explicitly rejected it. For the Supreme Court, it didn't matter whether consumers were getting internet content from their service provider or from somewhere else. As the court concluded, when an end user accesses a third party's website, paraphrasing here a bit, he is equally using the information service provided by the cable company that offers him internet service as when he accesses the company's own services. In the 2017-2018 order now under review, the Commission adopted that same insight, concluding that the user's ability to retrieve and utilize content via the internet made it an information service under the definition provided in the Act. Now, the Supreme Court in Brand X also said it was reasonable for the Commission to classify broadband as an information service because of two processing functions that provide important value to consumers and are functionally integrated into the final service. Getting a little bit technical here, but DNS, or domain name service, and caching. If you don't know, domain name lookup occurs whenever you type a web address into a browser or click on a link. Your service provider locates the host server for the web page in order to deliver the content to you. And caching is a function in which your provider stores popular content on local servers in order that consumers can enjoy a more seamless experience browsing the net. In the Restoring Internet Freedom order, the Commission again took its cues from Brand X and relied in part on those processing capabilities of DNS and caching. The petitioners claim that this is unreasonable today, but again, their arguments run right up against the Brand X decision. Now, you may be aware that in 2015, the DC Circuit upheld the Commission's prior Title II classification of broadband, concluding that that decision, too, was reasonable for the Commission to make. But the court also noted, in language that we highlight prominently in the current litigation, right in the introduction of our brief, that under the Supreme Court's Brand X decision, quote, classification of broadband as an information service was permissible, unquote. In other words, this case presents a classic example of agency discretion to make a regulatory choice under the statute that the Commission is charged with administering. As I explained, I think we have the much better reading of the statute, but under current law, it's at least, at minimum, a regulatory choice. So what's good for the goose here should be good for the gander, especially since in this instance, the gander comes with incredible credentials, a stamp of approval from the Supreme Court, and a history of past Commission orders reaching the same conclusion. On that note, I'd like to touch briefly on the public policy rationale for the Commission's action, and while both the order and our brief make clear that the legal discussion is sufficient, it provided as an alternative justification for the new regulatory regime a robust public policy defense. Looking at the record evidence, the Commission made the reasonable predictive judgment that a utility-based regulatory framework consisting of inflexible conduct rules with uncertain future application in light of a rapidly evolving market was likely to stunt investment in broadband networks, limit access to consumers in places where broadband has not yet been deployed, and stifle the smaller startup broadband providers who might otherwise deploy networks and enhance competition in poorer and more rural areas. The Commission noted that the allegations of harm in the record were sporadic and contested, and concluded that any incremental benefits that might accrue from retaining those rules would be outweighed by the cost to innovation and investment. Accordingly, based on that extensive record, the Commission adopted a mix of transparency rules, market pressure, and targeted case-by-case enforcement of consumer protection and antitrust laws to hold service providers accountable in appropriate cases. In other words, the Commission made an assessment, a philosophical assessment, that a lighter touch regulatory regime would better advance our shared goals of a free and open internet. Under Supreme Court and DC Circuit case law, federal agencies are fully entitled to adopt a different philosophical approach to regulation in precisely this manner following a change in administrations. One other aspect of the order worth mentioning is the Commission's decision to preempt any state laws that impose conduct rules similar to those that were adopted in 2015 and that the Commission has now repealed. Critics of the Commission's approach claim that the FCC created a regulatory vacuum by reclassifying broadband as a Title I service. But as I just explained, nothing could be further from the truth. Instead, the Commission made a conscious choice between regulatory approaches and replaced one, across-the-board conduct rules, with another, market-based transparency and ex post enforcement. Under the Communications Act, the Commission has authority to preempt contrary state laws under either regulatory approach with respect to interstate services such as broadband. In this case, the Commission reasonably concluded that a patchwork quilt of conflicting conduct rules at the state level would inhibit the very investment and innovation in the regional and national broadband networks that the Commission's light touch approach was adopted to encourage. Now, this has not prevented states from attempting to circumvent the order by imposing their own internet regulations on broadband, whether that be through executive order and the use of the procurement power, as we've seen in states like Vermont, or through imposing conduct rules of their own, as we've seen most notably in California. California is notable because it adopted internet regulations that swept even further than the 2015 federal rules. Among other things, the California legislation explicitly prohibits zero rating, which includes many popular free data plans. Due to the uniquely broad scope of these rules and their effect on the national broadband economy, the United States sued to enjoin these rules at the end of September of this year as inconsistent with the Restoring Internet Freedom Order. The state of California has since agreed not to enforce its new law pending resolution of the DC Circuit litigation, at which point the United States will be free to renew its motion to enjoin the statute. The Commission views this as a positive development for the policies set forth in the order, as it will prevent California for the time being from interfering with the development of nascent 5G wireless networks, as the United States attempts to compete on a global playing field to be the first to develop and deploy next-generation 5G networks. So to conclude, we feel confident in the legal arguments we are bringing to the DC Circuit. I would never want to predict the outcome of an appeal, but it is always nice to have both the U.S. Supreme Court and the Court of Appeals on record saying that the federal agency that you represent has discretion to make the very decision that you are now defending. So we look forward to answering the court's questions at oral argument early next year, and in very early preparation for that, I'm happy to take a couple of your questions now.
Okay, so if you have a question, raise your hand, and I'm going to call on you. I'll call on Lynn first. Just 1 second. A mic is on the way. So just for the record, state your name.
Lynn Stanton, TR Daily. So do you assert that the FCC could preempt state procurement decisions? And could you explain the rationale for interceding and a state deciding as to the requirements it would impose on someone who's selling stuff to the state?
Sure, and thank you. I mean, so I think an important clarification here is that the Commission has not taken an explicit position in the order as to whether or not the procurement orders or any particular procurement order is in fact preempted. Those orders do present different questions than the conduct rules that have been enacted in California. And so we have not yet intervened in any case presenting that particular order. I think we need to look at them each on their facts.
Hey, where did that mic go?
Hi, this is Kelsey Griffiths with Law 360. So it sounds like where the court decisions stand right now, you have a record that says you can either adopt Title I or Title II. And it sounds like right now you're saying that Title I has more legal footing, but that has yet to be ruled on. So what do you hope to get from a new DC Circuit decision other than an affirmation that you're free to do one or the other?
Well, I think what we're hoping to get is an affirmation that the Commission acted within its authority in adopting the Internet Freedom Order. And I think that that is simply a matter, really, of the court following the analysis in the Supreme Court's Brand X decision. In my view, we actually have an easier case than the Commission did in 2015 because we do have the Supreme Court's decision to rely upon. It was untested waters in 2015 as to whether the Commission could change course and classify broadband as Title II. So I think a very simple affirmation, it could be one paragraph as far as I'm concerned, would be victory as far from my perspective.
In other words, it could be a short argument, Brand X, and then a short opinion, right? One paragraph. It could work that way. You want to follow up, Kelsey?
I'm not predicting that, but.
So you don't think the 2015, 2016 DC Circuit affirmations will get in the way of that?
No, absolutely not. I mean, as if you look at our brief, we cite to the U.S. Telecom decision, which is the 2015 decision, right in the introduction to our brief. And the reason is that in that decision, what the D.C. Circuit said is that the Commission has discretion. It had discretion to classify this under Title I, and what it concluded in 2015 is that it had discretion to classify under Title II. What happened in that case is a party came in and asked the court, it said, actually, I think that you have to make this a Title II service. And the court rejected that argument and said, no, under Brand X, the Commission certainly could have made it a Title I service, and it did make it a Title I service. So I think that decision is very helpful to us.
Okay, we'll just take one or, I can, unlike the court, I can protect on here. We're just going to take only one or two more questions, and we'll call it.
Tom, I'm David Hatch with The Deal. I'm wondering, given the Democrats' takeover of the House, do you anticipate, like stepped up pressure for the FCC to consider imposing net neutrality conditions on transactions, regardless of the outcome of the litigation?
I'm not going to speculate on what the House may or may not do. I think we are prepared to defend our order in court, and I'm not going to speculate on what conditions we may or may not apply in future transactions. So.
Okay, well, if we have one final question, I'll take it. And if not, Gary? Steve, I'm sorry. I know.
Steve Efros, Cable
My
Guy.
apologies.
That's all right. Given that we're now seeing political pressure on the Republican side or the conservative side saying there should be curation because of the types of things being seen on the web, and from the Democratic side, also some pressure on ISPs to regulate what is allowed through on the internet. If the ISPs actually did that, if curation actually started, and we did the things that both sides, for different reasons, are asking be done, wouldn't that argue for the Brand X argument of Title I even more? In other words, if the ISPs are now asked to block certain websites for content reasons and actually become editors, which is what both sides are now asking for different reasons, wouldn't that argue that Brand X was right in Title I arguments that say, well, they're actually supplying services of their own content?
Well, I mean, I guess what I'll say is, putting aside any particular argument for or against curation, I mean, I think part of the hope with the transparency regime is that all of this is going to be public. And so, you know, there's no lack of people who are going to be scrutinizing these reports and looking at things very carefully. And to the extent that providers do things that are pro-consumer, that's great. To the extent that they're not, there'll be market pressures and where appropriate, regulatory action.
But it would be an information service at that point.
Well, it is, well, right. I mean, and what we have concluded is that we are well within our authority, and the DC Circuit has concluded this as well, to impose a market-based disclosure regime, transparency requirements, even under Title I, and that's what we've returned to. Am I right? Okay.
Okay, well, many of you know that oftentimes after one of our speakers has spoken, I usually have a little something right, whether it's a book or a ball cap, or you've seen all those things, all have Free State Foundation on them. And I'm so careful that I don't offend any FCC ethics rules, right? You've all heard that. Well, you know, since the General Counsel was here, I didn't even want to take a chance with one of our little ballpoint pens. So, Tom, all I'm going to say is it was really great to have you here. Tom was terrific. Don't look for anything in the mail. You were terrific. Let's please join me in giving Tom a big hand.
Thank you very much. Your gratitude fully complies with all ethical requirements, and I'm very happy to accept it. Thank you very much for the opportunity. Thank you.
Okay, now I'm going to ask Seth Cooper and Ted to come up, and we're going to move right into their segment. Seth and Ted both contributed pieces to the book, actually more than one. So I've asked them to just give us a little more substance about some of the things that they wrote about. I've also asked them not to give you so much substance that you won't want to rush out and buy the book. So that's their task, which I hope they'll adhere to. Again, Seth is a senior fellow at the Free State Foundation. I should mention that Ted, at the time he wrote everything that he wrote for this book, and even beyond that, was a senior fellow at the Free State Foundation. He is now, I want to get this exactly right. Ted is executive director of the Institute for the Study of Economic Growth at Wichita State University as of a couple months ago. But importantly for the Free State Foundation, Ted was anxious to and agreed to continue on as a member of our Board of Academic Advisors, and he's already contributed in that capacity, and we're pleased with that. So with that, I'm going to call on Seth first, and then we'll just move to Ted, and they're going to give you about just, let's say, 8 minutes worth, probably at most, of what they've written about or want to talk about, whatever. Go.
Thank you, Randy, and thank you for everyone who's here today. In our book, A Reader on Net Neutrality and Restoring Internet Freedom, we address many aspects of these topics. And one aspect, of course, is that overlooked question, the central legal question upon which the Restoring Internet Freedom Order will stand or fall at the DC Circuit, and that's the statutory definition issue. The FCC's redefinition of reclassification of broadband services as a Title I service, of course, has significant pedigree, as our General Counsel Tom Johnson just conveyed to us. And I think significantly, though, going forward, the FCC's determination will receive Chevron deference by the DC Circuit Court if it follows the U.S. Telecom versus FCC decision. So in other words, the court would not overturn the Restoring Internet Freedom Order's reclassification decision unless it were shown to be unreasonable and impermissible. I think that's highly unlikely. It can get dangerous to predict court outcomes, and I've been hesitant to do that in the past, but on this issue before this court, I say there's no way it gets overturned under Chevron. I think that's going to be the ball game on that one, and that's kind of a bold prediction, but that's mine. Now, an important result of the Title I reclassification of broadband is that it bolsters the case for federal preemption of state and local laws that conflict with federal broadband policy. So a handful of states have passed laws or issued executive orders that effectively seek to reimpose the repealed Title II orders at the state level. And the Restoring Internet Freedom Order comes out and says, look, these are jurisdictionally interstate services. Broadband networks and the traffic do not conform neatly to state geographic borders. If a state tries to get involved in that, they're dealing with interstate commerce, and it's going to have spillover effects on those services in other states. And in doing that, the Restoring Internet Freedom Order taps into agency and court precedents that regard information services as jurisdictionally interstate, as interstate commerce. And the Restoring Internet Freedom Order taps into important court precedent that accords preemptive force to federal agency policies favoring market competition and deregulation. And so it's very important, is what we have here with the Restoring Internet Freedom Order is not an abandonment of the field on broadband policy. The FCC did not create a vacuum for states to fill in however they wish. What they did is they established an affirmative federal policy favoring free market competition. So market competition is the policy, and they set up a deregulatory framework with FCC transparency rules and FTC enforcement on a case-by-case basis. And so in this book, one aspect of the preemption issue that I delve into in some detail does have to do with state executive orders and state procurement powers. A few states have purportedly used their procurement powers in such a way that it effectively reimposes some of the Title II order-like restrictions within their states. And as I discussed in the book, this, I believe, runs not only afoul of the general policy that I just discussed, but it runs afoul of the Supreme Court's market participant doctrine. And under that doctrine, state and local governments do importantly receive immunity from federal preemption when they're using their procurement powers of buying and selling. That immunity comes when they're acting like another participant in the market. But what we've seen in a couple of cases here is with the case of Vermont or Montana, they've exercised their procurement powers in such a way as to effectively constitute lawmaking. So in so doing that, the doctrine is sensitive to that leveraging of procurement powers, and it does not confer immunity when that takes place. So if you look at Montana's executive order, for instance, it prohibits the state from purchasing broadband services from a provider unless that provider agrees to abide by all of what are essentially the repealed restrictions under the Title II order. And they agree to abide by those restrictions with respect not to the state government, but with respect to all consumers throughout the state. So it's kind of a backdoor form of legislating. I don't think that's going to fly under the standard. And the last thing that I'll get into right now is our book also addresses the serious problems of legal uncertainty that were posed by the repealed Title II order. And those are important reasons not to go back in that direction. Professor Daniel Lyons offered an important contribution to this book. It's called Title II Reclassification is Rate Regulation. And he makes the point that the Title II order, the repealed order, did not forbear from the two most significant rate regulation provisions under Title II, Sections 201 and 202. And he explains how that provided an open-ended avenue for challenging any number of broadband service provider protections, and in doing so somewhat separate and apart from the Title II order rules themselves. And so I would, to get more on that, you'll have to read his contribution. I addressed in the book, speaking of the rules themselves that were repealed, I tackled the FCC's general conduct standard, or what it called its unreasonable interference and unreasonable disadvantage standard. So in addition to the bright line rules that it set up against throttling, blocking, and no paid prioritization. The FCC adopted what Chairman Wheeler then called a catch-all. It was a backstop. And that standard runs into a serious problem of constitutional vagueness. Under the Due Process Clause of the Fifth Amendment, laws cannot be vague. They have to provide sufficient precision and guidance to, one, let providers and people know what kind of conduct is prohibited and what's allowed. And it also has to provide sufficient guidance and precision to prevent the agency from engaging in arbitrary or discriminatory enforcement. So you actually have a strange situation of a standard set out ostensibly to prohibit discriminatory conduct that leaves itself quite open to discriminatory enforcement. And it's a totality that circumstances kind of standard, where the FCC set out 5 very vague factors for what amounted to unreasonable. I mean, what is unreasonable and what is unfair advantage? Well, the FCC said you can consider our factors. Here's one of them: end user control. According to the Commission, a practice that allows end user control is less likely to violate the general conduct standard. But we're cognizant that user control and network control are not mutually exclusive. And many practices will fall somewhere on the spectrum from more end-user controlled to more broadband provider controlled. But there also may be practices entirely controlled by the providers that also satisfy the standard. Now, I have no idea what that means, and I don't think that was clear at all. The other standards, the other factors don't help, and it got a little bit worse when the FCC acknowledged that there could be additional factors that they've not named that will be part of the consideration and the analysis. And it gets just a little bit worse when the FCC also gave itself the authority to shift the burden of proof effectively onto the service providers. So had this remained in place, you would have confronted a situation where persons or parties would have challenged a broadband service provider's practices, and the provider would have had the burden to show that it met this vague standard based on these vague factors, whether known or unknown. So fortunately, in repealing the Title II order, we got rid of that kind of vagueness standard. It took sort of a back seat to other issues, but I did address it with the book. So we hope you enjoy it. Thank you.
I'm very appreciative that after I ran off to Kansas, Randy still invited me to serve on this group. So it's a great honor to be on your Board of Academic Advisors. So I'm going to focus mostly on my paper on paid prioritization, which is chapter 12 in the book. And then I'll briefly mention chapter 19, which is where I wrote a paper on why the Federal Trade Commission is the best federal agency for policing any competition and consumer protection concerns that might arise on the internet. So as Seth mentioned a moment ago, paid prioritization is one of the 3 conducts on the internet that are given these bright line bans by the Open Internet Order. Now, if you've been to other Free State Foundation events the last couple of years, you've heard the industry people saying that, you know, two of the bans they could probably live with, the blocking and the throttling, but the paid prioritization ban is the one that really gives them problems. Of course, I argue that market solutions are better for internet consumers than any of the bans, but the one that seems to be the greatest concern to the industry is the ban on paid prioritization. Now, in the Open Internet Order, the 2015 Federal Communication Commission spins a theory that if paid prioritization was allowed on the internet, that would lead to fast lanes for traffic where senders pay for a priority, and then some slow lanes for everyone else. And then it goes on to theorize that allowing these fast lanes would mean that that creates a perverse incentive for internet service providers to really give lousy service on the slow lanes in order to force everybody over to the fast lanes where they have to pay for the priority. Well, that's not a completely implausible theory, but there are some problems with it, not the least of which that there really isn't much evidence that this kind of paid prioritization ever did lead to any, whether it even happened in the first place is debatable, but if it did, that there's really not any evidence that it led to any anti-competitive problems. But even more fundamentally, there's paid prioritization really is is all over the place in the economy. In fact, I think I can say with some confidence that everyone in the room has encountered paid prioritization arrangement somewhere like in the last week or so, and also that you're better off for having encountered it. For example, suppose you send a package for delivery, whether it's through the post office or through Federal Express or one of the private carriers. You can choose. You can choose regular delivery, or you can choose priority delivery that will get your package there faster. Now, so if that's what you value, you can pay a little extra and get that faster delivery. But if you don't choose to do so, I'm not aware of any any systematic problems of mail carriers slowing down deliveries of their regular delivery service in order to force people to pay extra to get their priority service. But even going beyond that, these charges for faster delivery are a revenue source for the mail carriers. That if they can make more revenues there, and then there's some competition in the market, most likely what that's going to mean is that for those of us who might send our packages through the regular delivery process, the carriers are able to pass on they've recovered their costs already, some of their costs already from the priority service, so they can charge less to more price-sensitive customers for the regular delivery service. And this is elsewhere too. So I flew out here. I was given the option at the airline that if I want priority seating on the airline, I could pay a little extra to get priority boarding onto the airline. Well, I didn't pay for it, and I got here at the same time that I would have otherwise, and maybe I paid a little extra, or paid a little less. Excuse me, other way around. Paid a little less because of other customers were paying for priority boarding. But all of this really took me back to something I encountered back in the 1990s when I was a staff attorney at the Antitrust Division. And back then we spent way too much time worrying about priority placement in retail stores, like slotting allowances at grocery stores or at bookstores. So if you've been in these kind of retailers, you see that there are some end of the aisle displays, or some products are on the end of the aisles, and making it really hard for you to miss them as you go through the store. And other ones are placed elsewhere in the store. Well, often there is a paid prioritization arrangement going on there that. Some of the retailers are paying to be on the end of the aisle, where you walk right by and you see their products, and others are not. Well, according to the open internet order theory, what's likely to happen if that were allowed to continue is that eventually the grocery stores or booksellers would place the products that weren't paying for paid prioritization, place them in places where customers would never find them, and eventually force their manufacturers to pay for priority placement. Does that happen in practice? Well, we've been alert to this issue for more than 20 years now, and I'm not aware of any examples of that happening. But even more to the point, as customers, we get benefits from this sort of priority arrangement. That presumably the reason why some sellers want to have priority placement is, they want to call it the consumer's attention to their product. They think we'll want to buy their products if we notice it. So there's some benefit to us as consumers from finding it. But then also it's another revenue stream for the retailers. So as long as the grocery store market is fairly competitive, if retailers are charging for paid prioritization for some products, and they take in this extra revenue, then through competition, they're going to be forced to lower their margins on the products that aren't paying for paid prioritization. So we're getting lower prices on the other products as a result of that. And yet another benefit is that this is really a great way of launching some products. That if you're launching a new product that you want to get into a grocery store, you can pay a lot for TV and radio advertisements and all kinds of advertisements, or you can pay a whole lot less and get priority placement inside of grocery stores. So rather than this being a scheme that will result in the biggest and best established sellers coming out ahead on it, and actually it may well, in fact often works out just the other way around. But I did just hint a moment ago at a situation where paid prioritization just might lead to anti-competitive harms. What if the grocery store market isn't competitive? Or there's another situation, like, for example, even if the internet providers, if some would argue that they aren't sufficiently competitive. Now, I don't think that's the case, but what if someone wants to argue that? Well, there is a possibility of an anti-competitive problem there. Well, the good news on that is what I discussed in the other paper. There is a federal agency that's very good at evaluating these kind of competition problems. The Federal Trade Commission. It's the top agency in the world at looking at these sort of things, as well as consumer protection issues. Now, the Federal Communications Commission has a lot of great people there too, a lot of outstanding economists, including the one who couldn't join us today, unfortunately, and many others too. So they have good people there, but they just don't have the institutional structure in place that the Federal Trade Commission has right now. And the Federal Trade Commission's been at this a lot longer. Randy actually wrote a paper about a year ago in which he pointed out that as a result of the open internet order, we actually probably had a time there where we had less consumer protection because we had the Federal Trade Commission being precluded from its competition consumer protection functions, and the FCC that was too new at this to be effective. So I think we're in much better hands now with the old arrangement being restored, the pre-2015 arrangement being restored, and the Federal Trade Commission being the lead agency on these sort of issues.
Thank you, Ted. Every time I hear Ted talk about paid prioritization, I'm even more convinced, despite the fact that you came for a free lunch today here. No, that was great. So what I'm proposing to do is just take a couple questions, and we're going to bring up Andrew Smith from the FTC. You see how the segues keep working here very nicely. Do we have any questions for Seth or Ted? Kelsey, just wait a moment for the mic. Just identify yourself, Kelsey.
Hi, Kelsey Griffiths with Law 360 again. I wanted to know if you think the free flow of information is a little different than the free flow of commerce when we're talking about some of these paid prioritization examples. If paid priority in grocery stores or in the airline example might be okay, does that change at all when we're talking about issues that might be implicating free speech?
I'm trying to think of how it would. I'm not coming up with any reason to think otherwise. As Randy points out, I'm an economist, so I tend to think of all of these sort of issues as what are the economic implications of it. So I think it should be the same, that as long as there's some reasonably competitive on the internet service provider level. And one of the criticisms I also make of the open internet order is it doesn't even make any attempt at finding that there is lack of competition. If there's a market concentration problem, it just asserts it. So
Ted, let me just put an addendum to Kelsey's question, because I think you hinted at this, but I want to ask you to expand on it and see whether my intuition is right. You said that sometimes the ability to be able to pay for a prioritization helps newcomers, or can help newcomers establish a foothold in the market and then become a competitor. I mean, I've argued that in the ISP context for years, and have suggested that's true. But unlike you, I'm just a lawyer playing an economist. Is that? I mean, can you envision that could be true as well?
Yes, actually, that's a very good point. Yes, glad you jumped to that. That if to the extent that it opens up more possibilities for speech to be disseminated.
Okay. Seeing no more questions, I'm going to ask you to join me in thanking Ted and Seth here, please. Okay. Well, I'm really pleased that Andrew is here. He probably never had any doubts he was going to be here, and I didn't either, except for the last week, whenever I sent him a message, it would bounce. I got a bounce back message saying I'm out of the country, and I'm returning on Friday, November 9th. So I didn't know where he was, and not asking him where he is now, but it is a state secret, but I was glad to see that, in fact, wherever he was, he got back here. Okay, well, Andrew is the director of the heretofore mentioned Bureau of Consumer Protection at the FTC. Prior to accepting that position, Andrew was a partner at Covington and Burling here in town, where he co-chaired the Financial Services Practice Group. And then earlier in his career, he was a staff attorney at the FTC, so he knows his way around the FTC. For the rest of his credentials, which are impressive in every respect, I'm going to refer you to your bio sheet, and without further ado, ask Andrew to come up, please.
Thank you, Randy. So first, my disclaimer, I speak only for myself, not for the commissioner, for any individual commissioner. A quick introduction, you guys probably don't need this, but we have two primary operating units or missions at the FTC. One is competition, which you heard about, and that's in our Bureau of Competition. The other is consumer protection, and I'm in charge of that mission. So I'm the director of the Bureau of Consumer Protection. So there are certainly competition issues raised by this, by the Internet Freedom Order, and its precursor. Those I will not address. And in fact, with respect to consumer protection, I think that the story there is relatively straightforward, and so I will give a couple of notes on internet service providers and how we police that space now with the Restoring Internet Freedom Order. And then I also want to talk, though, about data security and privacy, which are two issues that I think are of interest to this audience, two technology-related issues. So, ISP enforcement. We have jurisdiction over ISPs again. There was a brief period of time when arguably we didn't, I guess between 2015 and whenever the Internet Freedom Order was effective. We had litigation against two ISPs for throttling. So this is telling consumers that they had unlimited data. And in fact, what they in many cases slowed those data speeds down so much that the device was rendered meaningless, ineffective. And we charged that as a deceptive practice under Section 5 of the FTC Act. We brought two cases. One of which we obtained $40 million in redress for consumers, the other of which is still in litigation. And in that particular case, we were sent up to the lower court held that we did not have jurisdiction over, the company was AT&T, which offers ISP services, internet service provider services, but it's also a common carrier. And there is a carve-out from FTC Section 5 jurisdiction for common carriers like telecoms. AT&T argued once a telecom, always a telecom, that we had no jurisdiction over them whatsoever. We argue that no, only when they're acting as a telecom should they be subject to that carve-out. And we won in the Ninth Circuit, which brings us to today. So for a period of time, the AT&T conduct predated the 2015 Net Neutrality Order, right? 2015 Net Neutrality Order. Then there was a period of time between 2015 and more recently when those ISPs were reclassified as something, this Title I, Title II distinction were reclassified as an entity that would be outside of the FTC's jurisdiction. Now we have our jurisdiction back, and we stand ready to continue to enforce Section 5 of the FTC Act, especially against those deceptive practices with respect to the price, the quality, the quantity of service, similar to the cases that we brought against TracFone and AT&T. So that's the Internet Freedom story from the Federal Trade Commission, Bureau of Consumer Protection. Again, I'm pointedly excluding from that the Bureau of Competition, who may have their own issues with respect to the ISP market. So let's talk a little bit about data security. We've brought more than 60 cases alleging failures in data security over the last many years. Probably the first ones were, Svetlana, maybe 2005 or so. So over the last 10 or 12 years, we've brought more than 60 cases. We have more in the pipeline. Our data security program is alive and well. We are holding hearings on data security in December. My colleague, the director of our Office of Policy Planning, Bilal Syed, is here in the room, and he's organizing these hearings about consumer protection and competition in the 21st century. And in December, we will have 2 days on data security. The commission, so we have 5 new commissioners. Those of you who follow the FTC closely probably know that. One of our new commissioners started just within the last month, I think. So 5 new commissioners, new within the last 6 months. That's unprecedented. Since the FTC, it happened once before in 1915 when the FTC opened its doors. We had 5 new commissioners then as well. But since then, hasn't happened. So those commissioners, it's hard for me to count, but I think that 4 of the 5 had an opportunity to testify before Congress in an oversight hearing. And in that testimony, they testified in favor of federal data security legislation. So for those at the press table, don't quote me on this, it's in the testimony, but I think that if you do the math, we have at least 3 commissioners or maybe 4 commissioners who are in favor of federal data security legislation that would once and for all give us clear jurisdiction over telecoms. We talked about the telecom carve-out. Also over nonprofits. This is just for data security, right? Not generally. And in addition would give us APA rulemaking authority, so Administrative Procedures Act rulemaking authority rather than our sort of organic rulemaking authority, which is much more involved than APA. And civil penalties, right? So enhanced jurisdiction, rulemaking, and civil penalties with respect to data security. So that's something that I think we will continue, that the Commission will continue to support. They have supported it in the past, and they appear, as far as I can tell, to be supporting it now. I should also say, on the point of data security, that we are in the process of reviewing our Gramm-Leach-Bliley Act safeguards rule. So this is a routine regulatory review, but the safeguards rule, which regulates data security for financial institutions, has been relatively influential. I mean, at the time, it was actually quite revolutionary. This is 2002 that it was originally promulgated. It was a risk-based rule. It focused, it told financial institutions to assess the risks to consumer data in their organizations, to develop a plan to address those risks, to appoint someone to oversee the plan, sort of basic procedural steps, which at the time was something new, to have a rule that was risk-based rather than prescribing specific performance standards. Since then, data security obviously is a fast-moving area of the law, and it's now 16 years later. And so perhaps GLBA data security, this GLBA safeguards rule is, perhaps it's time for a little renewal or updating. We are in that process of reviewing the rule now. I would anticipate that there would be some sort of a notice of proposed rulemaking issued in the next couple of months. Let's talk a little bit about privacy as well. So we have, in sort of our privacy toolbox, we have a couple of important statutes. First is COPPA, Children's Online Privacy Protection Act. That has civil penalty authority. We've made rules under COPPA. We're active in the area of COPPA. I think the most recent case we might have brought is against a company called VTech, a maker of internet-connected toys, collecting information from kids who played with the toys without parental consent. That was a $650,000 fine. Another statute that we are active in enforcing is the Fair Credit Reporting Act. So that's, Randy mentioned, I was in charge of the Fair Credit Reporting Act program. So that's sort of my first love, is the Fair Credit Reporting Act. I once had a supervisor who said the 3 most important documents in Anglo-American jurisprudence are the Magna Carta, the U.S. Constitution, and the Fair Credit Reporting Act. not necessarily in that order. But it is kind of the proto-privacy statute, right? This is a statute that was enacted in 1970. So 30 years before Gramm-Leach-Bliley Act, a good 5 or 6 years, I think, before the Federal Privacy Act, 30 years before HIPAA. And so this FCRA was privacy before privacy was cool. And we have been actively enforcing Fair Credit Reporting Act, most recently on my watch, in a case against a company called RealPage that was trafficking in, it was a tenant background screener, and it was selling reports that were inaccurate to the extent that they included information about people who were not you, the applicant for the apartment. And in the tenant background space, what we're usually talking about here are things like quite incendiary types topics like criminal records, sex offender records, things like that. So you would have a criminal record that related to somebody else, and in this tight rental market, that matters a lot. Forget about that apartment, and sometimes it's not so easy to find another one, particularly in the right neighborhood at the right price. You get the picture. So FCRA, we're very active there in enforcing FCRA. We do have civil penalties in that area, and we got a $3 million penalty against RealPage. And then the final tool, not last but certainly not least, is our general authority under Section 5 to prohibit unfair and deceptive practices in commerce. I think, well, a recent case is our case against, which got some press, is our case against Vizio, one of the largest television manufacturers in the world. They had smart TVs, Internet of Things type, TV connected to the internet. TV was collecting all of your viewing behavior and essentially for advertising purposes, everything on the TV, not just what came in over the cable box, but over the top and from your laptop if you plugged it into the TV. Everything that was seen on that set was recorded, second by second and reported back. So we said that was a deceptive practice, or maybe actually I'm looking back at my other colleague, James Cooper, my Deputy Director for Economics. So was that also unfairness in Vizio? Yes, okay, so an unfair practice as well as a deceptive practice at $2.2 million in consumer redress. So on privacy, we're holding hearings on privacy through the good offices of Bilal again in February, where we're going to explore some of these issues. We have we regularly do these things called Privacy Con, which are conferences intended to bring in big thinkers, not lawyers, but technologists who publish, who announce papers at PrivacyCon, things like that. Focuses on emerging technologies. Our next one is scheduled for June. We're going to talk about Internet of Things, virtual reality, augmented reality, and artificial intelligence. And my last note on privacy is the EU Privacy Shield. So you may know that the GDPR, the new law, not new, it's actually an old law. It dates back to the Privacy Directive from 1995, but it's Privacy Directive on steroids. The GDPR is the EU privacy regulation. Prohibits the transfer of data outside of the EU to jurisdictions that do not provide adequate protection to that data. Well, it turns out that the United States is such an inadequate jurisdiction. Don't feel bad. Most jurisdictions are not adequate. I think the only ones that are maybe the Isle of Man and Argentina and possibly Japan now as well, but limited, right? So we have negotiated with the EC, the Department of Commerce has negotiated with the European Commission something called the Privacy Shield, which allows companies, if they make voluntary promises to keep data safe, to transfer data from the EU to the US. Hundreds of billions of dollars of transatlantic data flows depend on this Privacy Shield. The Privacy Shield has to be renewed every year by the European Commission. Our chairman and other representatives of the Commission were in Europe 3 weeks ago to argue in favor of renewal. It's now up to the EC to make the final decision. But this pitch that I've made to you about how we care about privacy, how we're active in enforcing privacy, is something that is also important to the Europeans. I will say they were particularly interested in our RealPage case because RealPage involved what they think of as artificial intelligence. What it was, data being fed into an automated decision-making process and coming out with the wrong decision because the data going in was bad. That's exactly the kind of thing they care about. It was, I think, not unsurprisingly, it was news to the Europeans that we had this Fair Credit Reporting Act that regulated data used to make important decisions about people. That was an idea that was a little foreign to them because it is a fairly, even though the statute is more than 50 years old, almost 50 years old, it's still a little counterintuitive. So I think that they were quite impressed with that. The other thing that we've done is where companies are adherents to the Privacy Shield, where they've made specific promises and they failed to keep those promises, or where they have failed to check the boxes with respect to their registration for the Privacy Shield, so they're not actually adhering to the Privacy Shield even though they say they are, that's where the FTC lives. So these companies are making promises that are false promises, and we bring enforcement actions against them. We have brought 4 in the last month, as well as a couple of others this calendar year. So that's an area where we're active in order to demonstrate visibly to the Europeans our commitment to privacy and our commitment to renewing the Privacy Shield. So with that, I will stop. If folks have a question or two, I'd be happy to take them. Yes, right here.
I think you ought to keep this mic in Lynn Stanton's hands here. Go ahead.
Still Lynn Stanton at TR Daily. Given that you brought throttling cases before for action before the 2015 order, do you still see under the 2017 order, which reclassified it as a non-common carrier, do you see your authority as the same? And do you see a problem with states that have statutes similar to the FTC Act, General Consumer Protection statutes, also bringing action against something like throttling as an unfair and deceptive business practice?
So the answer to your first question is yes, we have authority over ISPs for their network management practices, and we have, under the Internet Freedom Order, this transparency rule requirement that they actually disclose network management. So if they break that promise, then we have the ability to enforce. With respect to the states, that's not my department. We are charged with enforcing the laws that we're given to enforce, and we frequently cooperate with the states on law enforcement actions under their own FTC Act, little FTC Act, or FTC analogs. I don't see why we couldn't do that here too if there was some common cause. But if a state AG wants to bring an action under his own law against an internet service provider, I don't have any opinion on that.
Okay.
Yes.
Carl, just one second.
Hi, Carl Herkenroder with Communications Daily. I'm curious if the agency had rulemaking authority and direct finding authority, how would something like the Uber settlement look? Because there was no financial penalty, and it was 2 major data breaches. So I was curious what your thoughts are on that.
Right. So I would say that I think that the way that people envision this, when I say that the Commission testified in favor of data security legislation, I think that what folks imagine is that the bill would look sort of like past bills have looked, where there would be some general data security requirements outlined, perhaps similar to our GLBA safeguards rule, setting forth a process, then saying, okay, FTC, you have rulemaking authority to fill in the blanks, and you have civil penalties for folks who violate that rule. So it would all depend on what the rules, with respect to any specific case, any specific data security case, and we have plenty of them, it would depend on what that rule says and whether the company were to have violated that rule. But the reason that folks, I believe, find civil penalties appealing in the context of data security is that FTC generally has authority to require companies to disgorge illegal profits or to pay redress to consumers to restore them to the status quo ante. With data security, it's frequently very difficult to tie sort of a causal link between the security breach and some sort of harm to consumers. But there is still this idea that there is not, that there is a systemic underinvestment in data security, which, you know, and any data on that we're really interested in seeing. But to the extent that companies are not paying enough attention to data security, to the extent that they can push those costs of a breach off onto consumers or to other participants in the economy, then civil penalties might serve an important deterrent effect and to increase investment in data security to what would be an adequate level.
Okay, I don't want to give the impression, I don't think I have, that only press people can ask questions at our events, because, you know, we don't do that. So if we have one question from anyone that's not in the press, then we'll take it. If not, we're happy that Lynn Stanton and all of her colleagues were here today for sure. We always appreciate that. With that, don't leave right now. What I do want to say this about privacy, just real quick, and then we'll all say goodbye. You know, I think that one of the real advances in public policy now as a result of the Restoring Internet Freedom Order is to get in one place with a common enforcer a privacy regime that will apply to the internet service providers and edge providers alike, so that whatever the requirements are, and we actually filed comments today over with the NTIA, another part of the government, offering our views on what a privacy regime should look like. But regardless of how you define the obligations and duties, it seems to me that if you walk down, 14th Street and ask people, do they think that one requirement should apply for an ISP or an edge provider, you'd get pretty strange looks. So I think it's good that now we have what I would call a common enforcer. That's my view on that. What I want to do now, we were really fortunate today, I think, to have these distinguished speakers with us. Tom Johnson, FCC General Counsel, Andrew Smith, the Director of the Bureau of Competition over at the FTC, our own Seth Cooper, and Ted Bolema. And I just want to add, I mentioned this before, but I want to do it again. Mike Horney, who is Research Fellow at the Free State Foundation, contributed substantially to our book as well, and we're grateful for that. So if you'll join with me, just once again, give all of these speakers a hearty round of applause. I'd appreciate it. And we'll look forward to seeing you at our next event, rain or shine. See you then.